So, in passing the Partial Birth Abortion Act of 2003, Congress responded to the decision in Stenberg in two ways. First, Congress articulated that there was a moral, medical, and ethical consensus that partial birth abortion is a gruesome and inhumane procedure that is never medically necessary and should be prohibited. Asterisks. That statement by Congress is somewhat questionable, at least the fact when we deal to the medical nature of the question. Second, the Act language differs from the Nebraska statute, which was struck down in Stenberg. Among other things, the Act prohibits knowingly performing a partial birth abortion that is not necessary to save the life of the mother. Still, the law looks a lot like Stenberg and acts a lot like Stenberg. And in 7 years' time, the Supreme Court has switched how it's decided. And in the year 2000, where they struck down the law in Stenberg, in the year 2007, this law was not held unconstitutional. And Justice Kennedy, who was the very prominent dissent in Stenberg, writes the majority opinion in this case. There is a change in the tone of how the court argues this, largely because of the ideological change in the majority. The court enters in the discussion of women's mental health, saying that some women come to regret the choice to abort the infant life that they once created and sustained. This is an entirely new talking point that has not entered into the court's jurisprudence in abortion before. The health of the woman has always been confined to physical health previously. But now, for some reason, the court is weighing in on mental health at issue for a decision, and the Supreme Court holds that the federal government now should care about women's health and women's mental health. So in the end, the court holds that this federal ban on partial birth abortion is constitutional. But it never overrules Stenberg, though clearly the court goes in a very different direction of Stenberg. But one other thing that happens between the year 2000 and the year 2007 that should be notable is that Justice O'Connor is no longer on the court. Justice Alito has replaced Justice O'Connor on the court. And that really changes the tone of the conservative majority going forward. It's that Justice O'Connor is no longer part of the conservative coalition in this area, and her defense of the fundamental right of Roe has left the bench. It basically shows that Kennedy, at least in 2007, really was the swing vote going forward on abortion-related issues, and he remained there until he retired. It is not at all clear ideologically where on the court sits the swing vote on abortion, but numerous observers and commentators have noted that if Justice Kennedy is to be considered more conservative on this issue than Justice O'Connor was, and he was more conservative than Justice O'Connor was on this issue, the fact that Justice Kennedy has been replaced by someone whom is more conservative than him seems to signal that the right in Roe v. Wade, as articulated by Roe v. Wade, is less likely to pass through the ire of this court. In the Gonzalez case, there were notable dissents, perhaps most prominently Justice Ginsburg. And she argues that the majority in this case really blurs the line between pre- and post-viable abortions, and for the first time, a court approves a ban on abortion with absolutely no exception for a woman's health. Justice Ginsburg says she's alarmed by this decision, and this shouldn't be shocking, as she's long been a supporter of abortion rights, despite never truly being a big fan of Roe. She feels that the court has turned its back on precedent, and her dissent makes this very clear. But she makes one very strong point. Her strongest point is that there exists a significant degree of paternalism if we're going to have the Supreme Court and Congress weigh in on protecting a woman's mental health while simultaneously denying women the right to choose for themselves in terms of whether to receive an abortion or not. That is amazingly paternalistic. And because this newfound desire to protect women's mental health seems at odds, at least for Ginsburg, against the fact that there exists zero health exception in the denial of access to partial birth abortions. There is no woman's health exception. There is only a life exception. Yet the court and Congress as well justifies this decision by noting the conditions of women's mental health in this regard.